There we go.
Hello, everyone. My name is Erin Carranza, and I am the founder and host of Transformation Through Reunification. I'm a victim of CPS, and I am a parent, and now I'm an advocate. And I would like to take the moment to introduce you to who I've been told is the guru of CPS lawsuits and federal suits, Mr. Sean McMillan.
Hi, how are
Hi,
you? Thanks for having me.
thank you for coming on. It's you're kind of a big deal.
Really,
Yeah. Yeah,
that's kind
you're
of
a big deal.
interesting. Well, it's not on purpose. I'll tell you that.
What, to be a big deal?
Yeah, right. Just do your work, and
You do good work, it shows.
well, thanks for that.
It does.
So,
I mean,
anyway, what you told me, to come on the show is that you were, basically looking to ask some general questions and get some guidance about, how to deal with this stuff. And what I told you was, yeah, sure, I'll do it. Ask me anything you want. So that's sort of what we're doing. You can ask me anything. I'll give you the best answer I can, and we'll just see where this goes.
so I actually have been trying to get a hold of you for over a year, and I couldn't get a hold of you.
Oops.
You guys weren't taking cases, all
Yeah.
this stuff, and
We get really busy, and we have a hard limit. I actually don't take more than 16 cases
and you don't do
at one
dependency
time.
work, right?
And we do not do dependency work at all.
Mhm.
In fact, I stay away from that court to the extent that I'm able.
Uh-huh.
And we just focus on civil rights cases against social workers and county or state governments. I'm also admitted in Washington. Well, I'm admitted to practice in Washington State and in California. During COVID, I took the bar in Arizona and passed that, and I still have to do my moral character application. But once I get that done, next couple of months, I'll then also be admitted in Arizona. And everywhere I practice, the only thing we do is sue social workers. So we don't do juvenile dependency work. We just don't
No
mess
family
with
law stuff, none of that.
No, not at all. Won't touch it.
Mm-hmm.
Yeah, and we do have a limit. I do a very hard limit. It's 16 cases at any one time, and if we're full up, then we're full up. That's the end of it. I don't care, how great your case is. We're not taking it. And the reason for that, there's a reason for it, and it's that you can't. These are difficult cases. They're complex cases, both legally and factually complex, and they're horribly expensive to litigate. And you simply cannot do competent work on more than a handful at any one time. So we put a hard limit on it.
And they years, correct? It's not just 6 months. They're like year-long cases.
Well, more than a year. They're like years long. I can tell you the longest one that I had. I met the family when the child was 3 years old. He's now 18, and we just settled their last case like 6 months ago. So when we get involved with a family, it has the potential of being a substantial portion of their lives and my life. So we're careful about it.
I saw you give an interview, and you said that one of the things that you consider taking on the case is it's like they're another spouse, or you're in like this relationship with them because you spend so much time with the client. If you guys don't get along very well,
right,
it can help or hinder your progress in the case.
Right. That's one of the first things I look at when I'm looking at, potentially taking in a new case. The first thing is it interesting? It used to be a little bit different, but, now, I don't know, a lot of the stuff is sort of, how do you say it? The landscape has changed since from the beginning. The beginning, everything social workers did was just fucked up. They couldn't do anything right. And a lot of that is sort of that. Sorry, say it again.
Do you think people are just kind of accepted that this is the fucked up way they're doing? And
no. I think what's happened is through a lot of hard work and litigation, the county and state governments have improved their process over the last 10 years. It's much better now than it was 10 years ago. And they have, training in place that they give. They have policies now, warrant policies, things that they do, processes in place to prevent the sort of litigation that we used to do. 10 years ago, nobody was even getting warrants for any reason. Now they generally, not always, every now and then there's the errant worker who does some stupid shit. But by and large, most of our warrant cases have more or less evaporated. So they're doing things better in that regard. I'm not saying they're doing it perfectly, but they're not as bad as they were a decade ago when I started doing this stuff.
So I had no idea about CPS. They had an angel complex. I thought, oh, if CPS came in and took your kid, you're obviously a bad parent.
Right.
I had no idea until my daughter was falsely removed, or excuse me, illegally seized without a warrant. I'm trying to get everybody to say that. All of the comments to say seized, because it's very like, ooh.
Yeah, and I'll tell you one thing they always want to do in my cases is they don't like the word seizure. They don't like the word seized. They want to say temporary protective custody. I've taken the child temporary protective custody because that sounds good. If you're talking to a focus group and you say temporary protective custody of a child, 99% of the people out there that don't know any better are going to say, oh my God, they're protecting the child. This is such a good thing.
Yeah.
But when you reframe that, we do this in all of our depositions, at trial, and our discovery, you reframe that as a seizure. And it really is a seizure. It's, under the Fourth Amendment, a seizure is a taking, right? And that's really what they're doing, is they're taking the child into custody. So it's a seizure. You just call it what it is.
Right.
Now you do a focus group on that word. And again, 99% of the people are going to say, holy shit, a seizure. That sounds bad.
Yeah, that's kind of like abrasive.
Yeah, so it's like all about the framing. The government always tries to frame the situation in the most palatable words possible. And what you want to do is just redirect that wherever you can. No, this is a seizure, right?
So I know that, parents can sue under the Fourth Amendment and the child can sue under the Fourth. No.
You have to remember the Fourth Amendment under the United States Constitution. It's a prohibition against searches and seizures, right? So that's personal. That's your personal, a search of your person or a seizure of your person. That's personal to the person seized. So the child, for example, if they're seized from the parent, would have a personal Fourth Amendment right to prevent that seizure, correct? The parent, on the other hand, remember the parent has a protected liberty interest in the continued custody, care, supervision of their child, but that's under the 14th Amendment for the parent, because the parent's not the one seized. So it's always the Fourth Amendment for the child, 14th Amendment for the parent.
So here's my question is, my daughter, my oldest daughter, was traumatized by the removal of her baby sister.
Okay.
Does my daughter have the right to sue the county for removing her baby sister from her?
That's an unsettled question. There, arguably, under the First Amendment, there would be an associational interest, right? But there's a line of cases out there, sort of like a division. There's a majority view and a minority view, but there's a division. Under one view, yes, there would be an associational interest that's interfered with through that unwarranted seizure. And it's like a familial interest, right?
Yeah.
Under the other view, siblings have no protected liberty interest in continued companionship. So it's really a mixed bag. I don't know where the Ninth Circuit would come down on that issue because we haven't brought that up on appeal yet. That may happen sometime in the next year or so. But
Lola, my daughter, who was illegally seized, was with my oldest, Peanut, and it was traumatized. My oldest daughter, she's 20 now, but she was severe. Like she had.
Well, I was
traumatized.
If she's already 20, her statute of limitations is blown.
My oldest daughter.
Yeah. You have 2 years from the offending event to file your lawsuit if you're going to be within statute, and for the children, their statute under the federal claim anyway, under the federal 1983 claim, the statute doesn't begin to run until they turn 18. So she had 2 years from her 18th birthday to get her lawsuit filed if she was going to try to do that.
So no, that's Lola. She's 7. She's the one that was seized. My oldest daughter, Madison, was with Lola when she was seized, and she's wondering if she can sue under the First Amendment because they took her little sister.
Good point. You said she's 20, right?
Yeah, but she was 19 when this happened. She wasn't.
She was 19 when it happened?
Yeah, she's the older sibling.
She can try. She can try it, but there's, like I said, there's a split in authority. She may or may not make it.
I don't think I mean, maybe they do know, but how traumatizing it is not only to the parent and the child, but the siblings are affected, the grandparents are affected. Like, it destroys families when they just...
Yeah, they know that. They know that. That's well developed out in the literature. Mm-hmm. The research literature, all the psych literature. It's very well developed, the trauma that a family goes through when you take a kid away.
And it's crazy.
And also for the child themselves. In fact, there's a deposition I did of a Dr. Charles Sophie, and it's out online somewhere. It might even be on my YouTube channel. But I talked to him about the neuronal damage that's caused when you remove a child from its home. Mm-hmm. And yeah, it's very well established that permanent neuronal changes happen in a kid's brain when you do that. You subject them to trauma. And it doesn't matter whether it was good, that you're saving the kid from molest or whatever, or not. So if it's a righteous removal or not, they suffer the same neuronal damage. So the question is always going to be, is the damage we're going to cause by removal justified in light of whatever the danger is that we think exists? And if there's no real danger, it's really tough to justify putting a kid through that.
It's exigent circumstances, which is like immediate, like the kid is going to die or be severely hurt, right?
The general rule is that
without a warrant.
And this is defined in the case law in the Ninth Circuit. The general rule is that a government social worker, actually any government agent, whether it's a social worker, a cop, whoever, the government agent cannot lawfully remove a child from the custody of its parents unless at the time of the removal, that person, that government agent, is in possession of specific and articulable facts to show that the child's in immediate danger of suffering severe bodily injury or death in the time it would take them to get a warrant. In most counties, that's about 2 hours. But there's a second part to the test. Remember, it's a two-part test. Number one is there danger. The second part of the test is, and there is no lesser intrusive alternative means of averting that danger. So what that means is, say I'm the cop or the social worker, whoever. And I say, oh my God, this kid's in danger. They're going to get sexually abused within the next 2 hours because it takes me about 2 hours to get a warrant. Right. So we have a danger, and it's an immediate danger. I have to go to that second step. I have to do the analysis. Is there some other way to protect this kid from the sexual abuse besides just seizing her? Mm-hmm. Well, yeah, maybe I should transit her over to her grandparents' house. Or maybe I just get the dad out of the house and leave the child with mom.
I didn't mean to start that. I don't know how that happened. Sorry. That's my... I don't know why that popped up. I had it for later, but that's my interview with DCFS when they came to my house to take my daughter.
Oh, okay.
This was when they tell me, oh, we have no problem. There's no safety concerns. And then they remove her 2 months later without a warrant.
Oh, that's weird.
So this wasn't supposed to come up yet in the show. It just popped up. But I was looking for it.
Anyway, I don't know what I was saying, but
exigency.
Yeah.
And at the two-part, they have to meet both components to remove without a warrant, and in most counties, it's about 2 hours to get a warrant.
Yeah, and they have to look at lesser intrusive alternative means. Is there some other way to avert the danger than just taking the kid? And that's basically the rule. And if there's some other way to deal with it or to avert the danger, then they have to do that.
So Auntie Barbara has a question, and she said, if two were in immediate danger, then why would they leave the two older ones in the home and take the two little ones?
No idea. I can't really answer any case-specific questions, number one. Well, and number two, who knows? I mean, it's all going to be factually driven and circumstantially driven. It depends on what the circumstances were at the time. And, unless you know the whole story, you don't really know why they did that. You can't really speculate.
Most people think that common sense and the law are one and the same, and it's not. You would think that if they left 2 kids in the home, the other 2 kids would be fine.
Well, it depends.
Right.
It really depends on what the allegations are, what's the home circumstance. Mm-hmm. I'll tell you right now, for example, if we're looking at a drug situation, say that, there's a report or an allegation of drug abuse, drug use, and the social worker shows up, there's a 3 or 4 or 5-year-old kid, and then there's a 17, 16-year-old kid in the home. It's entirely plausible that they would take the younger child and leave the older one. Because the older one, they can communicate, they can run away, they can do whatever they need to do to protect themselves. They're older. Where the littler child may not have that same capacity. So in that circumstance, yeah, sure. Leave the older kid, take the younger kid. That happens all the time. But that's why I'm telling you, I don't want to get into here case-specific discussions. Right. Because I don't have the 5,000 pages of records in front of me that I need to look at to decide whether or not we have a righteous taking. Mm-hmm. And I'm just not prepared to do that. I'm not willing to do that, in this type of discussion.
A lot of work for a podcast.
Yeah, huge amount for a podcast. So anybody who has a question, I'm willing to answer it, but only in general terms.
Can you see the comments on the side of the screen?
I don't see any comments.
Of our screen, if you go onto usually it's on the right where it says comments, banners, brand, and private chat.
Yep, I see it. Okay.
And so that's where comments are. But also, Auntie, he's not a dependency court lawyer. He doesn't do dependency court, and that's dependency court when you're asking about how long. Judge, and that's typically they're supposed to do that.
I think it's within 72 hours from seizure to detention, or the detention hearing. It's supposed to be 72 hours. Yeah. But that's going to vary depending on, when they do the seizure. Is it a 3-day weekend? Is there an intervening holiday? Stuff like that.
And they also, COVID extended a lot of those times.
Oh, yeah. COVID wiped everything out.
Yeah. So my, took my daughter 2 months after the visit, blah, blah, blah. And then I had to wait a whole nother 45 days to see a judge before. Yeah. And it's an obscene amount of time, but they blamed COVID.
Yeah, that was a big problem for a long time. They did that with visitations too.
Oh yeah.
And they would just do video shit, whatever it was. I thought about taking one of those cases where they weren't doing the visitations, and it was a young kid too. And the problem with it is that politically, just right now, no judge, you're not going to get any traction going after anybody for violation of rights that arose from the COVID mandates. Just no judge is going to back it up. It's a totally political question. Mm-hmm. And unfortunately, a lot of these guys are, they're driven by politics.
It's funny that you say that because I'm in family court. I'm going, my ex is being arraigned on 37 violations of our custody agreement because he kept my daughter from me 37 times. So in 10 months, he kept her 7 months from me and said she had COVID every time. COVID.
Yeah, that's bullshit.
She didn't have COVID 12 times. She would have been in the Guinness Book of World Records. So, I know that they're going to be like, oh, well, nobody knew how to react to COVID or,
Well, that's why I ultimately ended up not doing the case is because, you put the brand of COVID on anything and they're gonna slide. Mm-hmm. They're gonna be given slack. And it's just a waste of time. You're not going to get anywhere with that.
So back to what are some good starting points for parents to even know if they have a case or not? Because everyone thinks, I'm sorry, but everyone thinks they have a case. Everyone thinks that, and they have been wrong. but what constitutes a lawsuit wrong versus just, oh, excuse me, that's fucked up wrong.
Yeah,
You don't like
that's a little bit of a difficult question to answer. In fact, I do a whole course on that for attorneys. It's an MCLE course. And yeah, I mean, I could just remind me, shoot me an email later, and I'll send you the PowerPoint presentation that I use for the course. Then you can just publish it to your people. It's basically a 2-day, 12-hour course. There's like 120 PowerPoint slides. And it basically goes through every variation of conduct, how you approach it, basically what a case looks like or should look like.
Right.
And if you shoot me an email on
starting point, like why my daughter's removed without a warrant 2 months later. That's a pretty big.
Well, it's not the 2 months later that's going to get you somewhere. That's not going to get you any traction. What gets you traction is, okay, number one, she's removed.
Right.
Okay, there's no warrant. Right. So then we have to look at the basis for the removal. Where did they remove her from? Was it the school? Was it the home? Was it the store? Was it daycare? Where did they remove her from? Why did they remove her? Why did they say they removed her? Was it, neglect? Was it, some medical thing? Was it drugs? Was it whatever it was? What's the reason?
It was, they used all of what you just said against me. Every single thing you just said, they said that I was guilty of.
Okay, so what specific danger was the child in?
Severe physical abuse and mental abuse because mother was.
This is the problem that you're going to have, is that if they had information at the time of the removal that would cause a reasonable social worker to believe the child was in danger, you're going to have trouble unwinding that.
But they.
Well, I mean,
I got receipts. That's all I'm saying.
There's the thing. Let's not get into a specific discussion about a specific case.
But that's my question. Is like, so I think I have a good case, but you're saying, well,
So this is what I would tell you to do if any parent, if you think you have a good case and you're having trouble finding an attorney, you file a complaint. That's all you can really do, is you go file your lawsuit. And now there's some basic components that go into a lawsuit. One is your claims for relief or causes of action. You'll need to figure out what those are. And then, you'll need to identify who the wrongdoers are. And you need to do it specifically. You can't just say, the county and all these employees wronged me. You have to actually come out and say, for example, Kalia Johnson, Robin Charlton, Kimberly Lawhead, name them, by name.
Right.
Did these things, and you have to say specifically what they did. You have to tell the story. I was sitting in my chair in the living room on the morning of June 3rd. This person busted, Mary Robulata busted in my front door and grabbed my child. And you have to actually tell the story with some measure of detail. And then, there's some elements to the complaint that you have to meet first. One, you have to have a jurisdictional statement. You got to tell the court, why I'm here, what law allows me to be here to press this claim. And then you would go and you talk about who the parties are, identify yourself as the plaintiff, then you identify the various social workers, who they are, what role did they play. So, you have like a emergency response worker. They do one function. Then you have a case carrying social worker. They do a different function. But to the extent that you have these people involved in your story, you'll describe in the parties section in your complaint who they are, what role do they play, what position do they hold, right? Who do they work for?
Right. That
sort of detail. And then you'll get it once you have all your characters. It's basically your cast of characters. You're, essentially writing a short story. And you're describing who the characters are and what they're going to do in the story. And then once you have all that laid out, you tell the story. And that sometimes...
screenplay?
Sorry, yeah, like a screenplay. It's very much like a screenplay. And in fact, in some instances, you'll even have dialogue. If the social worker, took your kid to a hospital, have you meet them at the hospital with your kid, and they want to do a medical exam, and you walk in with the kid, you sit down, they say, hey, you sit over in that corner. Then they come and they take your kid to go into the room, and you get up to go with them because you have a right to do that.
Right.
And the worker says, no, you don't get to come in. You sit down and you wait. That would be dialogue that you would put into your story, right? So, I mean, yeah, that's how you write it. And then once you have your story written, that's where you'd finish your story, and then you set out your claims for relief. This story, thrown up against this body of law, will support this claim for relief. And you may have 4 or 5 or 6 different claims for relief. And when I say claims for relief, that would be like, I'll give you an example here. I'm looking at one we're doing right now. That would be like deception in the warrant application, unwarranted seizure, coercion, unwarranted medical exams, that sort of thing. So yeah,
that's a big question parents have, is the medical exam.
Yeah, they can't do it without a warrant unless there's an emergency.
Right. What about even injections, right? Like shots and
yeah, it's as a parent, unless there's a court order saying otherwise, as the parent, until your parental rights are terminated, you retain parental rights. It's just somewhat interfered with because they have your kid. But that doesn't mean they can do stuff to your kid medically without your knowledge, permission, consent, or presence. Even if they have a court order allowing them to, say, do a sex abuse exam, they can't exclude you from the room, unless they have a good basis to, like you're having violent outbursts, or maybe they think you're the perp, something like that.
Right.
But so even in instances where they've gotten a court order, that does not give them the right to exclude you completely from the medical process.
Because I get a lot of clients saying, they took my daughter and they gave her shots without letting me know, or they gave her rape without letting me know.
They can't do that. That's a violation.
Okay.
That's a violation of the child's 4th Amendment right, and it's a violation of the parent's 14th Amendment right. So that anytime that there's medical stuff happening to a child, the agency either has to get a court order or a warrant, or they have to get parental consent, or it's got to be something like that's an emergency. The kid broke their arm in foster care, and we got to get that thing dealt with right now. But even then, they still should at least be calling the parents, say, oh, yeah, your kid broke their arm. We're going into surgery or whatever.
I have 2 clients right now where their child actually passed away in the care of the foster family, and they didn't find out till 3 or 4 days after the child passed.
Yeah, that sucks.
I can't even imagine that feeling. And
those are sad cases. I have cases like that, and they are sad cases. But
it's like I don't know how you could not tell them that their child is on either dying or has died why are you waiting 3 or 4 days?
Yeah, and they always have some bullshit excuse,
Yeah.
But that's the agency that you're dealing with. They're really not very caring.
No, not at all. And it doesn't seem like they care about families at all, even though their slogan is all bull crap. And I don't see.
You have to remember that and there's a deposition out on this too. If you look for, his name is Michael Riley, and he was the director of Orange County Social Services Agency. I did a deposition on him regarding the financial incentives and how the county basically structures its budget year over year for CPS. And it's essentially the metric that it's based on is the number of kids in the system. So there's this built-in incentive for the county to have as many kids at least as many kids in the system this year as they did last year, in order to maintain their same level of funding for next year, right? And what ends up happening is, the government agencies grow, they hire people. That's the natural tendency of government, is to grow, not to shrink. And the only way that the social services agency can really grow, at least the child protective services portion of it, is to get more kids, right? Then they get more money for next year. And so there's this weird, like self-fulfilling expectation that we're just going to grab more kids. Mm-hmm. And what that causes is the agency then casts a very broad net, and they end up bringing a lot of kids into the system that really should not be there at all. And, that causes its own problems, because then we have limited resources that are getting consumed going after kids that don't belong here, while we're leaving kids who really do need help unattended to. And the classic example of that, I don't know if you remember the Gabriel Fernandez story in LA. This poor kid gets totally ignored to the point that he's murdered while CPS is out chasing bullshit. Mm-hmm. Right? And it's like, what are you guys doing? That's like not the reason you exist. And that's one of the problems that we see developing when CPS is not paying attention to the right problems.
There's a case in San Bernardino County right now, actually, where the little boy was wrongfully removed or seized, and put into foster care, and the little boy was killed in foster care. And they didn't. I'm helping the parents get through it, but they covered it up. They didn't tell the parents right away. They knew that this foster dad was sketch and
left the kid there.
Yep.
That's so standard that they do so much of that stuff. It's really
and it's crazy that that's just standard practice.
Yeah, that's kind of that's why they get sued, man. That's why they get sued.
Changing legislation. How do we change that? Because the only thing I think is that we have to vote these people out. We have to get judges. We have to get new laws passed. But until those that are unaffected are
you really there's the solution that we have, and that's sue them one lawsuit at a time. But that's one at a time. And I'll tell you that the agencies do change. Once they pay out enough money, then somebody up in management says, "Oh shit, let's fix that. Let's not do that again." So it does change slowly when we're looking at policy changes or implementing training, things like that. But it's slow, and it's one case at a time, case by case. If you guys really want to effect serious change, you need to organize and work together, not have a bunch of little infighting crap going on.
No.
And work together and go after your legislators and actually get legislation.
You can't look like the crazy parent. You have to be organized, put together, because you don't want to be like, look at those crazy people out there. See, we need to take their children.
Well, this is the thing is that any parent who's been involved with CPS, you've already got a big black mark on you. Mm-hmm. Everybody says, "Oh, CPS took your kid. There's something wrong with you.
You must be a bad parent."
Or crazy or whatever.
Yeah.
So you're already digging out of a credibility hole just before you even open your mouth. If you come out, spouting off like a crazy person, angry, yelling, they did this, they did that, all this illegal stuff, nobody is going to listen to you. Nobody.
Even if it's true.
Yeah, nobody's going to listen to you. Doesn't matter. You got to be calm. You got to speak intelligently. You have to present well. You can't, be all scruffy like me. I'm scruffy and stuff, but I don't care because I'm not trying to get legislatures to do anything.
Well, I tell parents, when you go into court, don't wear a pot T-shirt into court.
Oh, for sure. You should dress in a suit.
Yes. You
should dress like you're going to a job interview to save your life, because that's really what you're doing.
Every time I went into court, you 100% put together. You don't let them see you looking sad, or you're just quiet and calm, and they're going to try to get you all antsy and poke, they're going to try to poke the bear and get you all worked up, but you can't become what they're accusing you of being. Right.
Yeah. If you get all worked up, and I used to do these programs for parents too, where I try to teach them how to file a lawsuit, that sort of thing. And they'd show up and they're like yelling and so angry and, just what about this? What about this? What about this? It's like, dude, I'm here to help you, number one.
Yeah.
If you're like this with me, I can't imagine what you look like in court.
So,
and people just don't understand all the vitriol, all of the melodrama. It doesn't get you anywhere. It just makes you look crazy.
So one of the first things I do is I tell the parents, and this was the hardest thing that I had to ever hear, was the removal happened and the seizure happened, get over it. Because before you know it, you are at 6 months, 12 months, or whatever.
And you're going to lose your kid.
Get over it. I'm sorry it happened. I know how much it hurts, but you need to be focused. You need to be doing A, B, C, and D, or your kid is gone before you know it.
Yeah, I can't tell you how many parents I've come across who had parental rights terminated while they were still busy, not
what happened in the beginning.
Yeah, that it happened. And the best advice I could give any parent, and again, I'm not a juvenile dependency attorney, so I probably shouldn't be giving advice at all.
This is just friendly advice to people on the internet.
Yeah, but I've seen a lot of these cases, all right? I've seen a lot of them. Mm-hmm. And I can tell you there's a lot of parents out there whose parental rights have been terminated because they could not get past the wrongfulness of the taking. They couldn't bring themselves to do the services. They couldn't bring themselves to, kowtow a little bit to the social worker because I know my rights and you're violating my rights while they're losing their kid.
No, you can come back and address all that after you get your kid back.
Yeah.
Get your kid back.
Exactly.
What you need to do. I almost missed the boat on that.
Yeah,
I was able to catch up. But speaking of termination of parental rights, is there anything a parent can do once their rights are terminated? Can they
in terms of civil litigation to get their rights back? No.
It's done and done.
The civil lawsuit is not going to unwind what happened to you in dependency court. It's just not possible. So get that out of everybody. Get that out of your head. I know I get people calling me saying, "Oh, I want to file a federal lawsuit because they did this in juvenile court."
Right.
Like, no, that's not the way it works. You have an appellate right at juvenile court. You had your shot. If you don't like the way it happened or you think there was a legal error, some other problem, go appeal it. That's your remedy. Mm-hmm. You are not ever going to be able to unwind a juvenile court judgment in federal court for any reason.
Well, that's really important for people to know that you can't just go and say, I'm going to sue you in another court and the judge is going to undo what another judge did.
Nope. Ain't going to happen.
So it's so insane that you can have a mistake in your lifetime. We're all humans and you get your life together, but not in time to appease the social workers and your rights get terminated. And there's no remedy to get your children back. It's horrifying that happened.
That's why, you raise the point. It's critically important. The first time that social, especially if you're looking at a drug involved situation, whether you're an abuser or not, maybe just occasional recreational user, whatever. The moment a social worker is knocking on your door, get your shit together.
Don't open the door, first of all.
Well, they'll come back. I mean, that doesn't help you. They're going to come back, especially if they have, allegations of drug involvement. They will be back.
Yeah, but it'll give you time to get a lawyer and get your shit together.
That's not going to help you. You're still going to lose your kids. I don't give a shit if you have a lawyer or not.
Right. Doesn't matter.
What's going to help you, the minute they're knocking on your door, I don't give a shit what your emotional hangups are, what your life problems are, what your issues are. Get your shit together. Get off the drugs.
Right.
Do not ever test positive. There's no reason for that. Once they're involved in your life, quit using the fucking drugs.
That's what I tell my clients. It's like, look, if you're not doing your services and you're not going to your drug testing, you don't want your children back.
Yeah, that's right.
It's plain and simple.
And you're not going to get them back. The court's not going to give a kid to some drug-addled mom or dad.
No, and they think that. And it's not an admission of guilt if you go take your drug test. Just take your drug test if you're not on drugs. Just go do it. How selfish are you to let your baby in foster care because you don't want to take a drug test? No.
Yeah, I get really frustrated with some of the people that I get that call, and they say, well, I just tested negative or positive on one test. It's like, dude, you've been with these people for 6 months. You know what they're into your shit for. Why are you taking drugs at all? Your kid is,
because it's hard. It's a grossly abusing. But you would think that when you are you're fighting these people, that you wouldn't put one toe out of line.
Yeah.
Your child is with strangers, and you are not.
Yeah, you want to take one more hit.
Yeah.
It's like, dude, come on, man, get your shit together.
Right. So, what about false claims? Can you sue for that outside of dependency court? Say you're out of dependency court.
You can sue for false claims, and that's a very, very difficult case to prove. I've had a couple of those cases, and I'll tell you, you can do it. It can be done.
What about filing a writ of habeas corpus?
Habeas corpus
to get your custody.
I haven't done one of those. I haven't done one of those yet. Mm-hmm. But I've looked at the issue in the past in a particularly egregious case. Mm-hmm. And
well, it's usually used for.
Well, they're usually used in prisoner litigation. Right? Yeah. They're usually used in prisoner litigation, but theoretically, writ of habeas corpus under the right circumstances could work in the CPS case. The problem that you're always going to have, even if there was a wrongful termination of your rights and the kid's now off in foster care or wherever, even if the court says, okay, look, I'm looking at your writ of habeas corpus, yes, you were wrong. Somebody lied about you. Here's the evidence. The judge made the decision based on that false evidence. Your kid got put somewhere else. But now we have to look at what's going on with the kid in this new placement. Mm-hmm. Is the kid stable? Is it a good placement? What's in the best interest of this child right now?
Right.
And that's why habeas, I think, probably is not going to work, is because it'll take you a year and a half to get through that process. And in that year and a half, the child doesn't stop developing. The child isn't put on hold. The child doesn't stop growing.
Right.
They're turning into an older child. And in that process, they're developing relationships and support systems without you. And the court will look at that and say, well, I understand your rights were violated, but where's the child best off right now? And it may not be with the parent.
That kind of gut-wrenching when you think maybe it's not with the parent. But
I get it. And I agree with you. But that's the law is, there's not a lot of emotion when you're getting into the analytical aspect.
So, how you say you have 2 years before statute of limitation expires. Mm-hmm. What if they have done this certain thing like 3 times? Does it start over each time they violate it? Each time?
Yeah, but only as to that one event, right? So you sort of have like a 2-year window that's marching forward. Uh-huh. So all the events that happened before that are outside that 2-year window, you're not necessarily going to collect damages for them if you win. Mm-hmm. But you can still rely on those events for pattern and practice type evidence. Mm-hmm. So even though you may be outside the statute of limitations, you may still be able to rely on past misconduct, as evidence.
So it's not like a reset of the clock if they do the...
No. There is an argument that can be made, regarding like continuing course of conduct, but I haven't seen that put into practice, in a jury trial, and I don't think it'd make it. Frankly, it wouldn't make it if I'm the judge. But
what are some things that people would claim as injuries? Like, so medically, just for me, for example, after my daughter was seized, I have stress, PTSD, separation anxiety, broken heart syndrome, stress-induced Crohn's disease. Are those things that are taken into account when you make a lawsuit? Yeah, for sure. In fact, what you're going to claim as damages are all of the emotional distress that you'd suffered as a result, your PTSD, anxiety, depression, and then physical manifestations of that severe emotional distress. So, for example, if you have a medical doctor, somebody with a license that's going to say, oh, your Crohn's disease was caused by the stress of losing your child, or your PTSD related, something like that triggered your Crohn's disease.
then yeah, arguably you could claim that as a measure of damages for sure. You know, any injury that reasonably flows from the liability generating event is going to be recoverable.
So my heart literally decided it didn't want to beat anymore when they took her away. And I was diagnosed with broken heart syndrome due to the removal of my child from a doctor.
Okay, do you have a psychiatrist or medical doctor or somebody that did that diagnosis?
Oh yeah. I went to the hospital. I was passing out. Like I was, my heart wasn't pumping enough blood
for
to my brain.
For sure, they'd have to testify to that effect. But yeah.
Okay, because I just know, people think, oh, I was stressed out, or there needs to be some well-defined things that are happening.
Well, the medical bills too, to the extent that you had to pay money to get treated, all of that is an item of economic injury. You know, if you have lost work, you ended up, maybe you had your business and your business shut down. I mean, that would be something that you would also claim as an economic injury. So you get both economic injury and emotional distress.
Right.
Those are both recoverable.
So other than obviously, get an attorney, that's the first bit of advice. What is something that parents should be doing if they plan to sue or they want to sue or they should be suing?
Keep all of their records. Keep every scrap of paper that you can get out of that case. Get it. Every report, every delivered service log, everything. And if you have an attorney, if it's a private pay attorney,
right,
tell them, order them to get discovery. You want the structured decision-making tools. You want the delivered service logs, the contact notes. You want anything and everything that agency is generating and storing about you in their system, and you want it during the pendency of your juvenile dependency case. What ends up happening with us, and it affects a huge delay, is a parent comes to me and says, oh, I've got this great warrantless seizure case. Okay, great. Right. Before I can do anything, I've got to get the records, because I have to look through all that to see, number one, do you really have a warrantless seizure case, right? And then number two, who are our defendants? What did they do? When did they? Basically, the story of your case. If you didn't save your records or get your records, it's going to take us a year, sometimes more, to get the juvenile court to break free with those records. And when we do get those records, they're going to be missing things. They're going to be highly redacted. It's going to be a mess. It's going to have to be, sorted out. It's a big pain in the ass. So if you as a parent, you're in a juvenile case, and something's gone wrong, or you feel like something's gone wrong, gather up all your documents. That's the biggest thing you can do to help your case later.
My fireplace just decided to fall down on me, so excuse me.
Deal with it. That's fine.
No. So anyways, I agree with you, and I always tell parents to document everything. Keep a running journal. Communications only through email.
So it looks like Jessica Ruckus had a question. How can you, without a lawyer, get all of your records? First of all, if you're the parent and you're a party to the case necessarily, you can ask for them, and you have a right to the records. And if they don't want to give them to you, go to the judge. File an 827 petition. You can get on the Judicial Council's forms website, download the JV 569 through 574 forms, fill those out, and file them. You're a party to the case. You're entitled to all of the records. Just ask for them. Your case was closed in May. Okay, fine. Go file your petition. Go file your JV forms right away. Just tell me you want your records.
Do you want to check the private chat, Sean?
Oh, the private chat? Yeah, hold on.
Yeah, because I asked you if you wanted to say questions.
Oh.
You got to do both of them. So the JV forms, obviously, your delivered service logs, obviously, you need stuff. How about stuff from their school and stuff from the doctors?
You should get all of it. You should get every record that exists. If there's a medical claim against the child or against you for your care of the child, absolutely get the medical records. If there's some claim that some crap is happening at school, get your school records. Even if stuff isn't necessarily being alleged at school, school records can go a long way to showing that there's nothing wrong in the home, right? If the child's getting straight A's and doesn't have any behavioral problems at school, and the social workers are alleging, say, neglect, well, then you have a pretty good argument in juvie court, right? It's like, Your Honor, what the fuck are they talking about neglect? The kids in honors classes getting straight A's, right? There's like this disparity in realities there, and that happens sometimes.
Jessica, I just emailed you the forms, the list of forms that you need. So the JV forms, I just sent them to her. She asked.
Oh, cool. Right on. Perfect.
So there was Auntie said here, they refused to give. What do they do if they refuse to give the records to the parent or to even to the child itself? What do you do? When you say they, who's they? The pendency court. When you go to subpoena the records.
Well, you don't subpoena the records. You file your JV.
That's right. JV forms.
574. Yeah. You file your 827 petition. The court's not typically going to refuse your record because you have a right to them. If they do, if the judge does refuse to give you your records, then you have to file an appellate proceeding because they unless they have a good basis to refuse to give you the records, you have a right to them. You're a party to the case.
Well, and if they didn't, so you'd have to be like a perpetrator, correct? You'd have to be.
Even a perpetrator has a right to their records.
Okay. So yeah. I'll say real quick, it's the JV forms are 180, 182.
No, 180 and 182 is get a change of order. What the JV forms for the
request for
petition for the request for court records and documents, agency records, is going to be the JV 569 through 574. Yeah, the JV 180, 182, those are all to see if you can get court orders.
Okay, the next one is my son was kept in a CPS office for over Thanksgiving all the way to Christmas. So I've been seeing that they're housing these kids after they remove them in the office.
Where is that happening?
Hello Fontana did it. I watched them put 4 boys in one room for over 2 weeks. I saw it with my own eyes.
Like at the office, no beds,
sleeping on the floor in sleeping bags in the DCFS office.
Wow,
I saw that with my own eyes.
I'd like to get a case like that, but I don't know how you'd get standing. But yeah, that's ridiculous.
I know the parents.
So what's the situation? Are their rights terminated, or what's going on?
No. The boys were removed because the neighbor called. The neighbor called and said, "Oh, the dogs are barking and the kids are blah 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 blah." So they removed these boys, but they didn't have anywhere to put them. So these boys were literally living in the Fontana office for over 2 weeks.
That's crazy.
Sleeping on the floor. I was like, look,
where are the kids now?
They are now split up in different foster.
Wow.
Yeah.
That sucks.
Yeah.
Is that also San Bernardino?
Yeah, Fontana and San Bernardino. San Bernardino County is pretty gnarly, man.
Yeah. Yeah, you guys got trouble out there. I have a case right now against San Bernardino County where the girl, it was a horrible case. She ended up dead. Got shot in the head and left at the side of the road. But
that's your case?
Yeah.
That's I heard a little bit about that on through the water.
Sad situation. Yeah. But that's the agency out there. They're pretty messed up.
And I wanted to kind of touch on the financial aspects of a lawsuit, because everyone thinks that You can just say, I'm going to sue somebody, and a lawyer is going to fund the whole thing for you.
Yeah. Mm-mm. See, this is the problem. Is one of these cases,
Mm-hmm.
if it ends up in trial and I'm in the case for 5 years, we get it to trial, that's $500,000 in costs.
Mm-hmm.
Right? I'm not going to put a dime of that up unless I think it's a solid frickin' case.
Right.
Right.
Because you basically have to front all of it, correct?
Yeah. Right. So when you say, "Oh, I'm going to sue somebody," I'll tell you first of all, there aren't very many lawyers that are going to take these cases to begin with.
Mm-hmm.
Okay, these are tough cases. They're complex cases. It's not red light, green light shit. It's not a personal injury case where I can see a broken bone so we can hit some insurance company. Mm-hmm. That's not the way these things are set up. So immediately you're facing off against a county who doesn't give a fuck about you, and they're willing to fight tooth and nail because their attorneys, remember, they're getting paid whether they work or not. Right. So, your case is just one more job in a pile of jobs that they need to do. It's not very meaningful.
No, your number. You're not a person, and they
right.
don't care.
So when you come in and say, "Oh, well, I'm going to sue," first of all, you're likely going to do it yourself.
Mm-hmm.
So if that's your plan, hit the books, study. Like I told you, I'll give you that course that I teach for other attorneys. It's got stuff in it that's probably beneficial if people can sit down and spend the time to go through it.
Yeah, I would love that because, like I told you, it took me over a month to write down what I thought was what a lawsuit would look like. I'm not.
Yeah.
And I could be way off base. I could be nowhere near what.
Well, there's one resource available to people, and some people make it, and I've seen a few of them where they took the templates, they put their lawsuit together, they made it stick, and they actually got money out of the county. But I publish a lot of my work online. Mm-hmm. It's just out there. I think there's a bunch on like JD Supra. There's some in the Facebook group, Families Against Government Abuse. But there's a lot of work product out there, and if you pull a complaint and look at how it's put together. Don't necessarily, look at the story because every story is going to be different. Mm-hmm. But you look at the structure of how the complaint is put together. And generally speaking, all of these cases follow more or less the same story structure. So you can actually take one of the complaints that we put out there on the internet and just kind of use it as a template.
Also, I wanted to tell everybody, if they haven't gone and watched your depositions, they need to. I have to tell you, you have me sitting on the edge of my seat and riveting stuff. I'm like, yes, ask this question. And she did. She said it. Oh, my God. Like that lady that said that her only job was to check if there was periods put in place.
Yeah, spell check. Right. That was so crazy. That was the Duval case. That was against County of Los Angeles. What a freaking nightmare those people are.
I had to rewind it because I was like, I did not hear that.
He really said that. I couldn't believe it either when it happened. I was all, okay, well, I mean, you have to make sure this stuff is accurate, right? So, yeah. So, well, how do you do that? It's like, what the fuck? Yeah, it was crazy. But that raised a point. One thing I'm going to start doing, because I do get a lot of, mostly attorneys asking, like, okay, I'm gonna do one of these cases. Mm-hmm. I'm doing this deposition. Mm-hmm. How should I approach it? How should I structure it? How do I get them to say what I want them to say? Because nobody's going to say, oh, yeah, I pulled the trigger, right?
Right.
So what I'm doing
the way you lay foundation is amazing. There's no getting around once you come in for the kill. There's no getting around that answer that you want out of them. You get it.
Yeah, and if they don't say that, if they don't give the right answer, they look like a bunch of idiots. And that's, and that's foundation's a big thing. But what I'm doing is I'm going to take a series of depositions and post them up on the YouTube channel. I'm going to get back on that. I started that years ago and it just took too much time. But I'm getting back on that. And what I'm going to do is I'll post the video, depo, and then the following week, I'm going to do like a little breakdown podcast. Say, okay, if you watch this video, let's go through it. This is why I'm doing these things the way I'm doing it. We'll march through, because everything I do in those depositions, even though some of them are really boring and really long, every single step of the way has a purpose. Mm-hmm. And sometimes we get to the end quicker, and sometimes it takes more time than you might want to spend. But everything has a purpose.
There was a couple of social workers I was like, ooh, this lady's horrible and condescending. Like the way I was like, I mean, it's really interesting the way you lay foundation and then the way you get. And there's a specific reason why you do that. It's because you show those in court, correct? You
exactly. What the reason that I'm usually, there's several different reasons that an attorney might take a deposition. You know, there's discovery depositions. That's where I don't really know what this person is going to say. I don't know how they factor into my case. I just want to learn their story. So you're just asking, you know, general questions. You don't necessarily have a point, right? Mm-hmm. Then there's the depositions that you are going to present in lieu of live testimony at trial. And that's essentially going to be your cross-examination, right? So what you want to do there is in fact, all of my depositions that I do are either for cross-examination of an adverse witness or for foundation from like a person most knowledgeable to pin on an adverse witness. So I may actually take the county's designated person. Mm-hmm. I may take their deposition. I'd be really pleasant with them. I'm not trying to pin them down on anything necessarily, but I know whatever they're telling me is the rule, this bitch over here didn't follow it. So I'm going to use...
You're the captain of the ship, right?
That's right. That's right. Exactly. So I can tell you watched a bunch of those things.
I did. I'm telling you, there's really good stuff. It's like, how can they sit there with these straight faces and be like, oh, to the best of my recollection, you know good and goddamn well that you did not do that. Or
yeah, and you know when they're lying. I mean, you can just see it. And if you didn't videotape it and say you're in trial and you're just reading the transcript, nobody can see what really happened there. But when you play that video for the jury and they see the lady just like scrunching around, her forehead's all scrunched up, and she's just really struggling to answer the question, it's like, oh, come on, lady.
It's really, it doesn't humanize them at all, but it
I don't think so. Yeah.
No, it makes them look worse. You know, everyone. I try to look at things. Everyone's human. We all make mistakes, and then you watch some of your depositions. You're like, oh no, that person just didn't give a fuck. They didn't care. Yeah. You know.
Yeah. See, that comes through on the video. It doesn't come through in the written record. That's why you have to do video depos. Mm-hmm.
What if you have an attorney, like my personal attorney, my family law attorney,
mm-hmm.
wants to do my federal lawsuit? Do you have a special course for attorneys that will?
That's the PowerPoint. That's the PowerPoint that I told you I'd send you if you shoot me an email to remind me. Also, if you look on my YouTube channel, I've done a bunch of courses, but I didn't, start recording them. I should have recorded all of them and then just posted them up there. Then people don't have to ask; they just go look.
Yeah.
But I think which ones are published up there? I think there's
we got the nuts and bolts one.
Yeah, well, there's the nuts and bolts from Arizona. There's one I did at Arizona State University Law School, mm-hmm. and that one I think the whole course is up there. Mm-hmm. And then there's another one that I did for advocates at I think Whittier Law School. And part of that is up there. And then there's one that I did just for parents, actually, out in Arizona. I did that at the Deer Valley Airport. And I think that one is partially up there.
Why Arizona? Why did you choose to branch out to Arizona?
Oh, because Arizona is a decade behind California in terms of the law. And
I lived there.
They're getting screwed so much worse than the people out here are now. Mm-hmm. Arizona, they're in the Stone Ages. But yeah, so that's why I ended up going out to Arizona. But the reason I did the course for parents out in Arizona mm-hmm. was because prior to COVID screwed up everything. But before COVID, and I tell a parent, if you can get 50 people to show up at any small airport in your community. I'll fly in there. I'll do a day-long course, teach them how to file their lawsuit, and all you got to pay for is the gas to get me there.
Right.
And maybe the room, because a lot of places they'll give you a room for free if you buy their gas. So, then we just go out and I do the presentation and have lunch, and that's it. So that was the rules. You find an airport near your place, you get 50 people that are going to attend. I'll come out and give the course for free. And I did a bunch of those. I didn't tape record any of them. I should have recorded them. But there's a few, like there's one I did in Sacramento, and somebody recorded it on their iPhone, and that was up online for a while.
Yeah, I saw that one.
But
I'm sure I could get 50 people.
Probably, there's a lot of parents getting screwed out there by CPS. It's not hard to put together a group. But after COVID, everything kind of got wonky because scheduling got screwy, and then the courts start jamming you on time, and everything's still sort of a little bit out of control. But probably 2023, 2024, I might look at doing that again. But for the moment, I just have so much stuff going on with backlog cases that it's really hard to find time to do something like that, because it really does take a couple days out to go do it.
Well, that's good to know, and we have gone over by 6 minutes.
Oh, yeah, a little bit. Sorry.
No. I don't want to keep you. I know you're a busy man, and it's late, and so.
Yeah, we get up at 4:30 in the morning every morning, so it's getting close to my bedtime about now.
I don't get up at 4:30, and it's almost my bedtime, so I don't know what to say about that. But I just wanted to thank you very much for coming on my little show here. I know that I learned a lot that I thought I already knew and I didn't, and I'm sure that everybody else did. So thank you for taking time out of your day. Sure.
Well, thanks for having me on. I appreciate it. And like I said, a lot of the stuff that you're looking for is on the YouTube channel. At least the coursework, for setting up a complaint, what the claims would be, that sort of stuff. And we're going to start that new process where I'm going to try to do it every week, where we post a new video deposition, and then the following week I'll do a breakdown. Okay, this is what we did, this is how we did it, this is why we did it, and basically trying to teach people, how to do a deposition, really.
Mm-hmm.
So
they're really important. Like, their deposition is probably one of the most important aspects of your case, I would imagine.
Yeah, once you get past the complaint, the challenges to the complaint, your depositions are where you're going to make or break the case. That's right. All right. Well, thank you very much. You have a wonderful weekend. And yeah, I like the fire in the background too. That's a nice touch.
Yeah, but I was afraid it was going to pop me.
It
started making loud noises. So, but I'm at my new house, and my furnace doesn't work, so I have to use the fireplace.
Nice. Cool. Well, you have a good weekend. Thanks for your time on this.
Thank you.
Right.
Bye.
Bye.